5.
Okay, H40 we dealt with last year. Maybe you could remind us of what it does.
Sure.
It's a civil.
Sure. So for the record, Michelle Childs, Office of Legislative Counsel, you should have in front of you Senate Judiciary strike-all amendment to H40, which is an act relating to non-consensual removal of or tampering with a condom. The change that is in this amendment, even though I did it as a strike-all just for kind of ease for reporting on the floor, but the language is identical to the House version, but you'll recall that in the House version, it's in Title 13 in your criminal title, and that's because when it was originally introduced, it had a criminal and a civil provision, but then when they voted it out and the House passed it, it just has the civil provision. And so what I did for your Senate Judiciary Committee amendment is just redesignated it in Title 12 so that it's in your civil court procedure title, and but the language is the same. And just as a refresher, it's creating a clear civil right of action for someone if they have been harmed by someone who they've engaged in a sexual act with, and they had consented to the sexual act with the understanding that a condom was going to be used, and then that person, without the consent of the other person, either removed the condom or tampered with the condom, rendering it ineffective. So it's just civil. So then the only change that the Senate is making is designating it in Title 12 instead of 13.
Okay, we had quite a bit of testimony last year on this. Right.
I have to say, I find this sentence, lines 10 through 14, just kind of impossible to read through. Is there a way to so I'm thinking, like, the way I read it is that a condom would be used, and then intentionally and without consent, they remove or tamper with a condom. But it almost sounds like the consent includes intentionally and without consent. And then by the time you reach without consent, you realize you misread the sentence. So that's my only my 2 cents.
Yeah, and I got, in reference to that also, first of all, I don't like passing bills that just aren't enforceable, and I still question as to how this is enforceable. But what if, for instance, say it's a bad condom, or the condom falls off, or what else? Can they still use this as, you know, he said, she said, one word against the other? I mean, where's the fine lines? I don't know what happens if the other party says it was intentional that they came on. That's what I'm saying.
Yeah. Well, that would be the tough piece, right? If you were.
I mean, I think it would be a challenging case to bring. It's civil, and so it would be up to the court, the jury, to make a determination by preponderance of the evidence whether or not the plaintiff can meet the burden.
I don't know how you prove that.
Yeah, I mean, we wrestle with this all the time, the intentionally piece. And also, as you say, like proving that somebody removed it as opposed to it coming off, that's tough to, I mean, I suppose if if one person confronted the other and said, you removed the condom, and they said, well, yes, I did, but for this reason, that's the only way I can see that you'd be able to prove that they.
Well, it has to be explicit understanding that a condom will be used, and then intentionally removed or tampered. So that asked to have the two elements. Yes, Senator Machine.
Thanks. To add to the statements that might be made that could be used as evidence, people also unfortunately record themselves doing a variety of things that they shouldn't be doing.
Yeah, sure.
And you'd be surprised at what people record themselves doing. This is one of the things that falls into that. So I agree that it's something difficult to prove. But I mean, you still need evidence to prove it. And just like with any other civil or criminal violation, you collect your evidence, both exculpatory evidence and inculpatory evidence, and present it to a jury or a judge, and they make the ultimate decision if it meets that threshold of evidence.
I think probably the House went through the same process, and that's probably why they made it civil rather than criminal. I think it is a pretty high bar, because you'd have to prove somehow that it was intentionally done, and that you didn't give consent to having it removed. And I suppose it could be both.
I mean, I don't condone this in any way whatsoever. That's not what I'm saying. Okay, I just want to open up the floodgates on this either, as far as saying, well, they still can. That's my concern there.
Well, I'm fairly, I don't mind voting for the bill, because I do think it's fairly high bar. And for those cases we heard about last year, and the witnesses we heard about, I think it's something that doesn't hurt to have. Gives that opportunity when it's so blatant.
So it is possible that someone could try to bring an action under tort law, making an allegation either that they were harmed, but you probably have to show something like that you contracted an STI, or there was a pregnancy. You might be able to go after for a battery or something like that, but it's not clear. It's a little murkier there, because you're kind of falling back on civil tort law but this is just sometimes what y'all do. We'll kind of recognize a specific type of action, saying that it does have a remedy if you meet the elements and you can prove it in court. So
if I might, there's no jail time that goes along with a civil offense.
no, it's just
So
someone
what
who
are they-
is harmed.
Right,
So
is this a money thing? What are we looking for here?
well, I think it provides for compensatory, punitive damages, as well as reasonable costs and attorney's fees. So compensatory could be, if someone did contract an STI, or if there was an unplanned pregnancy. I'm not sure. You probably want to take testimony on what kind of damages somebody might receive in that. California does have a law. I don't know whether or not there have been cases brought under California's law. It's relatively new, maybe 2 or 3 years ago. But there's no jail time. It's just a civil suit between two parties.
And there's a lower bar of proof.
Preponderance of evidence.
Yeah.
Mm-hmm.
Yeah,
But you're correct. It would be, I think with all sexually based offenses are quite difficult usually to prove, whether you're talking in the civil or certainly in the criminal case.
I don't know, this simple bill, we love that term, right? Simple bill here.
There's no such thing.
There's no such thing. It's just, I don't feel comfortable with it right now. I guess first of all, I don't want to follow California the rest of my life. Okay, but lastly, I guess I'd like to hear how this plays out in a court of law. If someone has experienced this or whatever else. I know it's about the alleged victim. I realize that.
Yeah.
There's just still some loopholes rules that I don't quite grasp.
Mr. Chair?
Yep.
In terms of that sentence that I mentioned, I can show this to Michelle, but one possibility might be saying, and this basically starts on line 12, no person shall intentionally and without consent remove or tamper with a condom prior to or during the sexual act in a manner likely to render it ineffective for its common purpose, comma, when consent to the act is made with the explicit understanding that a condom would be used.
So you just want to put the,
Right, because I just, the way it's on the page, it seems very difficult to read through. Partially because we're putting what we're prohibiting in the third line rather than in the first line. But anyways, that's
sure.
what it means.
Senator.
For Senator Norris's question, is there, I could try to find some attorneys who might be able to testify who do a lot of civil work. Is there a specific, you just want to know how it plays out in court?
Case law, anything good. I didn't realize it's civil, but I just not quite comfortable with it right now. I need a little more legalities of it, what's happened. The bar is that kind of local problem. I mean, if it was even like clear and convincing or something, it's versus beyond a reasonable doubt. I mean, but the preponderance of evidence is real low when you're talking about alleged victims and accused in this particular. And like I said before, I'm not against this. I'm not comfortable with it as it sits right now. So case law or something from someone. Is there any other state besides California?
I don't know. I know that there's been legislation in quite a few states, but California was the first, and I don't know if in maybe the last year or so since this passed. At the time when the House did it last year, it was just California, but I'm not sure if any other states were added in the last year.
I'm thinking of, I think it was Julian Assange in Sweden got arrested for not precisely this, but when he fled the US, he went to Sweden, and I think he met someone, they had consensual sex with a condom, and then he, during the night, initiated a second round of sex without a condom, and so he was brought up on charges there. So I don't know if they have the stealthing piece in their law, but they definitely have a similar approach. Not that that answers Senator Norris's question about US applications. But,
I'm looking through my file because it's I'm trying to think. So there is legislation, there's federal legislation. I can check and see whether or not any other states have adopted it.
There's a few blank pages in there, but
Yeah, my printer.
I just did a quick search and it looks like multiple other states have pending legislation, but California is the only one that's done it.
Did you-
As of April 2023.
I add something, Sarah Robinson, Deputy Director of the Vermont Network. When the House considered this legislation, they brought in an attorney, Alexandra Brodsky, who has actually litigated some of these cases and could really speak to that, the civil process, and was one of the kind of subject matter experts that also led to the elimination of the criminal component of the bill as originally introduced, and was in favor of the civil remedy only. So she may be a witness that could be helpful to the committee if you decide to take additional testimony.
was it Alexandra or?
Alexandra Brodsky, Brodsky.
So we have a suggested change.
what was that?
You have a suggested change.
I gave my potential edit to Michelle.
Okay. Do you wanna, is the committee comfortable with
Mhm.
change. So it'd be helpful, Michelle,
Sure.
do draft 1.2 or 2.1.
Mhm. I can do it when you're taking testimony on 173.
Okay. And then we'll come back to H40 and vote on it, the bill as amended. So, if we could take the H27, the controlling.
Yeah, so I think Ben has copies for you. Last time that you discussed the bill, I had given you a list of some of the other states that had either coercive controlling the term specifically in their definition of abuse for civil protection orders, or they had something similar to the concept, and Senator Sears asked to take a look at both Maine and Connecticut. So, so you should have copies of both of those, and I just wanted to draw your attention to the language for these. So if you take a look at Maine, does everybody have Maine?
Yes. I think I have Connecticut, and Maine is the second one.
Maine's right on top.
So you see Maine, it says Maine
Maine,
revised statutes
yeah,
up at the top there.
Maine is small.
Right. So if you look there, so you have the definition of abuse, and if you look at subdivision C, they don't use the term coercive controlling behavior. This appears to be language that Maine has had at least for a little while. I wasn't able to go back and track the history of it because as you'll see there at the top there, it says effective March 6, 2024. So they just redid this whole chapter. And but you see the language there, subdivision C, abuse means compelling the person by force, threat of force, or intimidation to engage in conduct from which the person has a right or privilege to abstain, or to abstain from conduct in which the person has a right to engage. I looked at the case law for this. I did find a couple of cases. There was, and so there's one from 2008. And I'm just going to read to you a little bit of the factual pattern so you can kind of understand of what they considered to fall under subdivision C. So in Cole v. Cole from 2008, evidence supported finding that husband engaged in conduct which compelled his wife and child by force, threat, or of force or intimidation to abstain from conduct in which they had a right to engage, and thus warranted order for protection from abuse, because the evidence showed that in regard to the wife, the husband destroyed an internet box to prevent the wife from communicating with friends and family, and attempted to keep wife isolated in the home, away from visitors. And in regard to the child, testimony was given that husband's conduct prevented the child from sleeping during normal hours and resulted in the child staying up all night. So there was another second case that I found, which is Clark v. McLean from 2014. Ex-boyfriend's threat to place nude photographs of ex-girlfriend on a website with her cellular phone number and her work number so that users could call her and arrange a date, and to publicize the website to ex-girlfriend's coworkers and potential employers by sending emails and promoting it on search engines, amounted to compelling ex-girlfriend by intimidation to abstain from conduct in which she has a right to engage, and thus boyfriend's conduct was abuse, supporting an order for protection. So those were the two ones that I was able to find there that fit within that definition.
Michelle,
Mm-hmm.
on this same statute, says C is compelling a person by force, threat, or force or intimidation.
Mm-hmm.
And then it says to engage in contact which they have a right or privilege to abstain, and to abstain and they have a right to engage.
Mm-hmm.
I was looking for a carve out for parents and children the way we were talking about the other day? Is there one, or?
I did not see one, no,
Okay, so a person would include a minor.
yes.
So could a minor use this against a parent who is preventing them from going places that they want to go, that they otherwise have a right to go, but the parent says, you're not going?
Again, I think you would have to go back to looking at what's reasonable in terms of a parent's right,
Mm-hmm.
you know, to the care, custody, and control of their child, and determining, can you go to this party or not? I mean, something like with the case there was, you know, keeping the child up all night, not allowing the child to sleep in the evenings, things like
think
that.
Connecticut addresses that better,
Okay, we can go
in
to,
my opinion. But go ahead.
Yeah, and, so those cases are from Maine.
from Maine.
Are there cases where children are actually using the Maine law to bring suit against their parent when it is not valid? Like, I guess I want kids to be protected from the type of behavior, like, as we've talked about before, I actually have a problem excluding kids from this protection order. So I guess what I'm wondering is, are kids using this in a way?
I'd have to take a look.
Okay.
To remind you, as passed the House, and on page 2, lines 5 through 7, Judge Zone had concerns about this. Would be more complex cases that may require expert witnesses. In other words, the conduct between a child 18 years of age and the child's parent guardian involved in the exercise of the parent's constitutional right to care, custody, and control of the parent's child. Whereas in Maine, I think it's more descriptive. If you look in B in the Maine law, course of control of such family or household member, which is a pattern of behavior that's purpose or effect unreasonably interferes. If you go back to our concern on line 21 of the House passed version on page 1, where it recklessly causes, as I read it, to me anyway, unreasonably engaging in any flow. And then isolating the family household member, et cetera, depriving the family household member of basic necessities, controlling, regular, and monitoring the family household movements or behavior, et cetera, compelling the family household member by force, threat, or intimidation, but not limited to threats based on actual or suspected immigration status, engage in contact with family household has a right to abstain from conduct that such family house member to pursue, committing or threatening cruelty to animals that intimidates the family household member, or forced sex acts, etc. I think it's more inclusive, but it also gets rid of the word recklessly and the complexities that the judge saw.
My biggest problem with this bill is section 2. This legislative intent, and then the specifying of all of these things that would constitute this. Maybe I'm wrong, I just don't remember operating in this way before, where we have one piece that doesn't include these details, and then we list them, but kind of as a guide for how to read the other piece. But, that's where I have my biggest problems, are those things that are laid out and specified there on 4 and 5. What comes earlier, I can deal with more easily in my mind, but on page 5, and I know that the House Committee reached that as kind of a compromise on what would be in the actual statute and what wouldn't, but it seems like it's having it both ways. We're gonna have these, you know, this list of behaviors that would constitute controlling and coercive behavior, but we're gonna put them in an intent section rather than in the actual statute. I don't know. Is that,
It makes sense.
it makes sense the way they've done it, or?
No, it makes sense that it doesn't.
Yeah,
I've never seen this before. I've seen intent before, but I've never seen it that descriptive.
mm-hmm,
But in the heart of the bill, I think the two biggest problems that I see is the B little I
Mhm.
mm-hmm,
and the term recklessly.
yeah.
I don't know if that fits. It has to be reckless, whereas in Connecticut, I think they tell us what, maybe I'm just, no, so it doesn't discriminate against children by making them special class and talking about constitutional rights for children, which are constitutional rights of the parents' constitutional right. The care, custody, and control of the parent's child.
Mhm.
That is very confusing in light of some of the things that can happen.
Mr. Chair, I think you're right about, on page 1, coercive controlling behavior means a pattern of conduct that recklessly causes or has the effect of causing. My question there was, it seems like if you has the effect of, you don't need recklessly because you don't need to prove it.
Right.
So it seems like we could just eliminate recklessly there and has the effect of.
Because of the effect of causing a reasonable person to.
I mean, because that's the way it ultimately would be limiting anyway.
Just trying to decipher my notes for what, the exact thing you're talking about, and I think that we had discussed changing it to the knowingly standard, which would be similar to what we have for stalking as well. Does that sound familiar? Because I remember, I think you had brought it up the last time we talked about this, and I'm looking at my notes that perhaps we had talked about.
Yeah, that's definitely a higher standard than has.
Because that creates essentially strict liability.
Well,
If we were to change it though to the knowingly standard, would that mean that the person would have to know that it is going to cause significant emotional distress? Because that's pretty concerning to me if we're going to raise it to say, well, it only applies if this person knew that it was going to cause significant distress, because I don't think you could ever use it. Like the behavior may still be abusive and may still be deeply harmful, but if that wasn't my intent and I didn't know it was gonna do that, then.
I think, and correct me if I'm wrong, Michelle, but I think that wouldn't they use the reasonable person standard?
Yes.
Yeah, so, if a reasonable, so if a reasonable person knows that, having a kid kneel on a hot grate for hours is going to cause injury, both physically and mentally, then I think you could assign the knowingly mens rea to this. That's my understanding from the example that we heard of last time.
Make knowingly and should make it clear. That way, that person couldn't argue, well, I didn't know the hot grade was.
Well, you should have.
Reasonable and prudent, right?
Well, and the hot grate is physical abuse, so this is not, like, this is about manipulation and emotional abuse. And I think that it gets trickier when you reasonably should have known that, repeatedly suggesting to a child that if they do a certain thing, they'll never see another parent again or something like that. It just, I have concern with raising it to the knowingly standard.
And to go along with that, on page 2, to suffer substantial emotional distress. We talked a little bit about that last time. I just think that's such a difficult, I mean, it's a difficult thing to quantify somebody else's substantial emotional distress. So again, I can imagine a couple where someone is in tears because they feel like their partner is being controlling. But you'd have to say they are in substantial emotional distress. They're sobbing. But I can also imagine a version of that where what is making them sob shouldn't be illegal. It's just they should break up with the person. So that just seems like a very, and I know it's judicial, judgment about whether that bar has been hit, and it would depend on the evidence that's offered. But it just seems to fear for your safety or the safety of a family member, it seems to me is easier for me to feel good about. To suffer substantial emotional distress is just a very vague thing, and it triggers the whole bill, right? If the judge finds that there is substantial emotional distress, then you can get the order. So anyway, that's a concern I have.
So I could be wrong, but I thought perhaps, and maybe it just got bumped because of scheduling, but didn't you have at one point someone scheduled from the National Council of Juvenile and Family Court Judges, like because this is model legislation, or am I thinking of another? Ben, does that ring a bell, or I thought there was, no, okay, all right. I thought there was somebody who,
Yes.
Right. Something. I'm listening to the conversation. I wanted to just mention two things. Because it's a civil proceeding, the defendant's intent really doesn't matter. I mean, the burden is on the plaintiff to prove the impact of the behavior. And so I think that is why the purpose or effect language was originally used. And that is language that's also used in the Connecticut statute, is purpose or effect. Because it's a civil proceeding, the burden is on the plaintiff to meet the burden. And so the Vermont Network's position would be that we would much prefer the purpose or effect language, because it is much more aligned with kind of the process of a civil proceeding, rather than the court essentially creating a mini trial to determine whether the knowingly standard has been met.
so if I can get if I can summarize or kind of make sure that I understand folks' concerns, I can go away, I can work with Sarah a little bit and see if, I don't know, maybe a melding of the things that you like and elimination of the things that you don't, and see if we could come up, it sounds as though there's, some discomfort clearly with the House proposal. Would I assume that you would just want section 2 out, the purpose and intent out? Okay. Or I don't want to make assumptions. I'm just trying to, and I don't want to jump ahead. I'm just trying to figure out how to marry all the comments.
Yeah, well, so in looking at both the Maine and the Connecticut language, it looks like a lot of what is included in the intent section in this bill is actually just in the statute in their versions.
Well, I mean, like Connecticut does have examples where it says including, and then it kind of gives examples like what is contained in section 2, correct?
And it looks like Maine has some as well, although not quite as extensive. So I certainly don't mind getting rid of the intent section, but I wouldn't want to lose, I would actually be more supportive of including some of that language in the actual statute, much like Connecticut does.
I like the Connecticut law
You like Connecticut.
better
Mhm.
because I think it is more descriptive
Mhm.
and would give better guidance than the intent section, first of all. And secondly, it avoids what I don't understand, quite frankly. And I would think would get into a huge argument in a courtroom on the B(i) does not include conduct between a child under 18 of age and a child's parent or guardian involving the exercise of parent's constitutional right to care, custody, and control of the parent or child. That's a wide open
Mhm.
thing. And I can think of all kinds of situations where maybe the parent's interests aren't in the best interest of the child. And we've seen, perhaps not in Vermont, but certainly nationwide, instances where children are certainly emotionally and otherwise controlled by parents who do not have the best interest of the child at heart, but don't actually abuse the child with the emotional. And it's not as simple as you're grounded next week for that behavior.
So are you comfortable with I agree with you that I think, for me, out of the three, I think Connecticut's is,
Well, I think it's
Is a
more
little clearer.
inclusive of what this committee's trying to get to.
right. So
Which
is
is
there
having
anything
in law.
about Connecticut that you're uncomfortable with, or is there something in
I think what I want to go back to is the anonymous witness and what she had to put up with, if you think about what she talked about. And I think Connecticut more correctly would encompass that behavior from the person, the domestic, what do you call it?
abuse?
The abuser.
Yes.
Yeah, thank you.
And I'm right in that what we're doing is expanding this for purposes of a relief from abuse
Right,
order,
strictly,
not,
does
yeah.
not affect, domestic assault, statutes at all in Title 13. This is strictly for, obtaining a relief from abuse order. And it's amending the definition of abuse. So when you go through and you apply for an order and you have to write your affidavit, and you have to have one of those pieces in the definition that you see on page 1 of the bill, and you can see what's there currently, which just, involves physical harm or threat of physical harm.
The only thing in Connecticut that I'm leery on, I was leery on in the other bill too, which is on second page, C, controlling, regulating, or monitoring the family or household members' movements, communications, daily behavior, finances, economic resources, or access to services. The other ones have to do with force, threats, cruelty, isolating, depriving. C, it seems to me, gets very slippery in terms of, we talked last time about spouses that monitor each other's use of their joint checking account, or parents who do control all of these things: movements, communications, daily behavior, finances, economic resources, or access to services. All of those could conceivably fall under parental, relatively normal, ordinary parental functions. So if C isn't there, I'm fine with the rest of it, but C, it seems to me, is at least potentially liable to misreading or abuse.
You would still, it would have to be read in the context of it unreasonably interfering with a person's free will and personal liberty.
Right, but back to the minor child. Maybe too much information, but my ex-wife is right now monitoring our 19-year-old, her finances on a very tight you know, she's very tightly monitoring her finances and also her movements by way of her phone, for various reasons. And so I just feel like it's hard for me to vote for something when I know lots of parents who do monitor their children's finances, for instance, and economic resources. You can also get into like with cell phone apps, they may want to monitor the content that the kids are looking at. So that's the one that gives me the.
But if it's common that parents do that,
It wouldn't be
I
considered
wouldn't
unreasonable.
think it would be considered to be unreasonable. I mean, I think that's a
Mhm.
pretty, I understand what you're saying,
Yeah.
and, you know, my daughter's about to go off to college, and, yeah, that's something I think a lot of parents do, because you're footing the bill, and you gotta make sure they're being
So,
smart with their budget, or
Unreasonably.
that they're safe, so they put you on the app, so you know where they are.
the controlling language in Connecticut is unreasonably engaging in any of the following.
But unreasonable is already in there.
Oh, no, I'm just
Yeah, that's
looking
what
on
he's
page 1
Mhm.
of Connecticut
He's
Right.
talking, he's
4.
Oh, okay.
paraphrasing.
Oh, okay.
Include, but is not limited to, unreasonably engaging in any of the following. Unreasonably. Now, maybe there's a better word than unreasonably.
I think I wouldn't do that, because you're being redundant. The test is that it unreasonably interferes with a person's free will and personal liberty. The others are just examples. They don't stand alone.
Mhm. Yeah,
So you
'cause I
take
think-
that as an example, and then you just
Yeah.
are using, just like I was the person who was threatening to put explicit images out there, you know, you take that and then you apply the test, you take the factual circumstance and you apply the test.
Well, and I'm uncomfortable removing C, just given, I mean, even the testimony from our anonymous witness about the acts of not allowing communication with people and not, like, that, when it is unreasonable, is abuse. And, you know, I think also, particularly given that we're talking about relief from abuse orders, this type of early intervention may save lives and may prevent emotional abuse from rising to the level of physical abuse. And I certainly know, in speaking to individuals who have a partner who's never laid a hand on them, but doesn't allow them to buy certain things or doesn't allow them to access certain people, that is harmful and abusive. So I think when paired together with the unreasonably limiting personal liberty and free will, it isn't going to apply in an instance where a parent says you are grounded, you may not go to that party.
Is this, in Connecticut, is this to get a relief from abuse order? It is.
And so this would, if we transferred this to this proposed bill, section C would still fall under the substantial emotional distress part, right? So you know, you'd still have to prove that there was either fear for your safety.
Well, I
or
thought you
fear
guys
of
were
unlaw-
talking about just
I think she's
taking
talking-
the definition of coercive, the definition that you have in 27, removing that and replacing it, maybe I misunderstood, replacing it with Connecticut's definition.
Yes.
So that it would be coercive controlling behavior means a pattern of behavior that in purpose or effect unreasonably interferes with a person's free will and personal liberty. And you could stop there. If the examples feel as though they're more problematic than they are helpful, you don't have to have the examples.
Well,
It's
I
up
do
to
think
you.
The examples are more helpful than problematic, because it gives, you know, the plaintiff and the layperson has to still prove
Well, I think it,
by some, but I don't know what is the standard
It's preponderance.
preponderance of the evidence that this behavior is any of these things or something else that, I don't know what else it might be, but there's probably something.
Right, and it would be for the court to just determine, whether or not, my husband doesn't allow me access to our bank account and I'm not allowed to have any money unless he physically hands it to me and he's controlling my money, and versus I'm gonna be looking at my daughter's bank accounts because I'm putting the money in the bank account and I wanna see how she's spending it, and then it would be up for the fact finder to determine whether or not that's unreasonable interference with the plaintiff's.
And if I could just note, in these cases, judges are always considering the facts that are presented to them in the context of the relationship. We'll be looking at kind of that context. The other piece in terms of whether the examples are helpful, I think it's always helpful to remember that most of the litigants, that the plaintiffs that come forward to seek a relief from abuse order are doing so pro se. And so the actual language that is laid out in the statute is on the application for a relief from abuse order, part of their guidance as they are filling out a plaintiff and affidavit. So the more that there is essentially plain language that really allows a plaintiff to understand the kinds of protection that's available for the kinds of behaviors, the more helpful that will be, I think, just to the general public. I certainly think that these examples are helpful and illustrative to plaintiffs as they are determining what kinds of relief they are seeking.
I agree.
And I know we're on opposite ends on the parental piece, but that's really my only objection to see. I don't object to it for adult to adult. It just seems to me that it's describing a number of things that many parents do that I worry that we would be, I don't know.
Well,
Understanding that unreasonably is.
In that case, you could, with some revision of the language, use B1 on page 2 of the House bill.
Right, although I know Tanya and you, Senator Sears, were looking to also protect those under 18, and I get that. It's just, there's this, I feel like, to me, it seems pretty clear why it was carved out, because it's very hard to describe what a reasonable parent might do in terms of these things and what would grade into unreasonable. So for instance, these days you can, with your child's cell phone, you can track where they are, what they're spending, who they're talking to, etc. And I know parents who do that. It's not what I do with my kids, but is that unreasonable? It seems to me unreasonable that they do it, but I don't think they feel it's unreasonable, or society as a whole has decided necessarily that it's unreasonable. So that's where the ambiguity comes in for me.
Well, playing around with redrafting into Connecticut and then put a choice of something that coercive controlling behavior does not include conduct between a child and parent, guardian, although that flies in the face of what Joni said about how difficult it might be. But at least having it there for the committee to discuss the next time we take up the bill. And secondarily, you might consider the only legislative intent, actually, that might be helpful would be is the intent of the General Assembly to recognize that coercive controlling behavior is a form of abuse.
Would you like me to keep that?
Yeah, but I would put it in where we usually put intent sections.
Mm-hmm. So you want me to make
Section 1.
You want it session law and not codified?
Yeah, but it would provide some guidance to a court. Coercive controlling behavior is a form of abuse. I don't know, maybe it could be codified, I don't know. But I don't, I think it's at least if I was gonna do it, intent, that would be the one I would use.
I will, can I just make one comment on that, is that you can fully decide to put it in there, but what you're doing in section 1 is defining abuse to mean coercive controlling behavior.
Understood.
And so it doesn't,
Just gives that.
okay. I just want, so if you don't want it, I don't.
Well, I think the
but you
house
can't.
would say, well, we want our intent.
Okay.
Say, we give you your intent.
Yeah, it comes as, I really have concern about removing this possibility for kids, not only because in rare, I imagine it's rare instances, this is happening to children in an abusive way, and the complex developmental trauma that creates for children can last a lifetime. I also would be really curious if in the states that have expanded, there have been any cases of a child who was grounded or those type of this sort of being abused in that way. And I don't know if you can even find that, but I really have concerns about not protecting children with this,
Well,
so.
I do too, and so if you could work with Sarah on that and Judge Solnit, and to try to address his concern, that it would bring more complex cases, as well as requiring expert witnesses too. I mean, we've all had our share of witnesses here who disagree on certain philosophies and ideas, and as to what parental rights are and what they are. So I think I would be more comfortable with Sarah and you and Judge Solnit could work on that particular section. I realize, and also maybe run it by Senator Hoover. I think his concern is valid. What is coercive? And I always thought my parents were fully coercive. In some of their behavior.
My dad, for sure. Sorry, Dad.
Well, yeah. I remember my mother saying, is it time to get the stick?
Which would probably be prohibited by
I think
other
that's coercive, but,
physical abuse.
well, she never used it.
Yeah,
But it was the time to get it.
with my mom with the wooden spoon.
So I think that pretty well sums up the committee. The Senate Judiciary Committee has an extreme desire to pass a bill that would allow for relief from abuse from somebody who's being coercively controlled, but thinks that there are other ways to do it.
Connecticut place.
All right, I'll work on a new draft for you.
Well, yeah. I don't think this is scheduled again.
Not for this week.
So, yeah, we could at least try to, and maybe some other states are dealing with the same thing, I don't know, who are actively working on a bill right now.
I can definitely reach out to certainly Connecticut. I know those folks well at our peer organization there to ask how issues of parentage and parent-child relations have come up in these cases. So I will definitely do that.
All right, well, we're actually ahead of time, about 4 minutes. Believe it or not. So if anybody needs to take a break, would you like, 2 minutes? Or would you rather jump right into page 173?
I might be game for a 3-minute break. I could use a cup of coffee.
Okay.